Butler.
Thank you, Presiding Officer. As Deputy Convener of the Justice Committee, I place on record my sincere thanks to the clerking team, to SPICE and to the many witnesses who gave invaluable evidence to the committee at stage 1. This bill is one which seeks to enable the establishment of new business structures within the legal services industry in Scotland and to deliver an appropriate regulatory framework for individuals and organisations which provide legal services. The reforms contained in the bill have the stated aim of creating a more flexible, up-to-date regulatory framework for legal services and consequently the achievement of improved access for all to high-quality legal services. At first sight, these policy objectives appeared to committee members to be worthy and relatively uncontroversial, not to say somewhat dry, even esoteric. In truth, they have excited a degree of passionate debate and a level of controversy within the profession, the like of which has not been seen in modern times. The result, as many members have referred to, of a recent referendum conducted by the Electoral Reform Society on behalf of the Law Society of Scotland, followed by the Special General Meeting of 21st April, served only to illustrate the division of opinion within the profession regarding the bill. In his letter of 26 April to members, Mr Michael Clancy noted with admirable diplomacy that, and I quote, "These expressions of democracy show there is no consensus in the profession on two important areas, namely external ownership and solicitor participation in a minority role in an entity with other professional participants." Unquote. Quite so. In his briefing to members of the 26th April, Mr Mike Daly of the Govan Law Centre puts it rather more robustly, and I quote, "We do not believe the bill as presently drafted contains appropriate safeguards and that the particular concept of alternative business structures adopted in the bill does not lend itself to acceptable safeguards for those citizens requiring access to justice or a legal service. Indeed, according to Mr Daly, safeguards need to be put in place to, and again I quote, protect the public interest and the independence and professional ethics of solicitors subject to ABS. Now, this current division within the legal profession places elected members across this chamber in a very awkward position, to say the very least. What is clear is that there needs to be a commitment to a positive dialogue both within the legal profession and between practitioners and politicians to ensure that a workable compromise can be agreed which meets the salient concerns of a significant proportion of those in the legal services industry in Scotland. Now, these Labour benches are committed, as my colleague Richard Baker said, to the extensive debate necessary at stage 2 of the bill process to deliver legislation which has at its core the maintenance of access to justice. There must be no unintended consequences which restrict access to justice for any section of Scottish society. At the moment, especially with regard to the make-up of alternative business structures and external involvement in such organisations, there is need for more dialogue and for a willingness to listen to constructive proposals from those who have expressed concerns with regard to these aspects of the bill. I am confident that the ministerial team will listen carefully, as will the committee, to such suggestions. Indeed, the Minister, in his formal written response to the committee's Stage 1 report, must be commended for his constructive engagement with many of the concerns it raised. For example, in terms of section 36 of the bill, the committee noted that a restriction on eligibility to be a licensed legal services provider may, and I quote, restrict the way in which not-for-profit organisations can provide legal services, unquote. The committee expressed its sympathy for the concerns raised by Citizens Advice Scotland in this regard. I am heartened by the Minister's promise to give this issue further consideration and the discussions his officials have already had with CAS in respect of its desire simply to allow Citizens Advice Bureau directly to employ solicitors by way of exemption, I believe, in terms of section 26(2) of the 1980 Act. Further, I am cheered by the ministerial team's willingness to look at the matter of the role of the Lord President. The committee shared the concerns expressed in much of the evidence about the extent of proposed ministerial involvement and the perceived threat to the independence of the legal profession as a consequence. In his written response, the Minister noted that he had been listening to those who have called for the Lord President to have an equal role to the Scottish Ministers, and that the Government is considering an amendment at stage 2 to give the Lord President a greater role in the process of approving regulators. That is a good thing. I am also heartened by the Minister's assurance in his speech that the Government will bring forward, and I quote, additional sanctions regarding the fitness to own test. I think this is only prudent. Now, Presiding Officer, such a listening approach is both welcome and necessary. It must be the approach adopted if the Stage 2 process is to be successful in making the amendments necessary to shape a robust piece of legislation acceptable to the whole legal profession, legislation which addresses the major concerns over which there is still no agreement, and that is concerning. In that regard, I do hope the Government will consider carefully what my colleague Richard Baker described as constructive proposals, such as the one outlined by Mr Mike Daly for a co-ownership model of alternative business structures with a 75 to 25% split. He made this suggestion in his fairly detailed briefing paper, which members will have seen. And on that clear understanding as to the way in which we should proceed, Labour will support the general principles of the bill at 5 o'clock tonight.